Today I have a child custody case for you from Calhoun County, Michigan, the courtroom of the Honorable Brian Kirkham. This is a pretty good example of what happens when two people hook up and then one proceeds to grow up and raise a child and the other doesn't. I hope you enjoy.
Yes, Your Honor.
Okay. Ms. Reed, do you wish to make an opening statement or proceed to proofs?
I wish to make an opening statement.
Okay.
So the parties in this matter share one minor child, and that's Lauren Wines, and she is 6 years old. The most recent order for custody and parenting time was entered September 17th on 2019, where the parties share legal custody. Plaintiff Lyric Cannon was awarded primary physical custody, and the defendant has parenting time every Saturday from 12:00 p.m. until Sunday at 6:00 p.m. There is no holiday schedule ordered, and there is no additional parenting time ordered other than that one overnight on the weekends. Plaintiff is requesting a change in legal custody as the defendant has abandoned the child for the last 3 years and has not participated in any legal decision-making regarding the child throughout the child's life. Plaintiff is also requesting a change in domicile to allow her to move to Tucson, Arizona. To allow the change in domicile, plaintiff must show by a preponderance of the evidence the factors enumerated in NMCL 722.31 parens 4, the so-called DeFornino test, and support that her motion for this change in domicile. Testimony will show that a change in domicile has the capacity to improve the quality of life for both plaintiff and Lauren, and that defendant has failed to utilize his parenting time under the current order, and that it's possible for modification of the current parenting time schedule to allow a relationship between the defendant and the minor child, and that there is no motivation for some sort of financial gain for resisting this move, as testimony will show that this move actually has the capacity to increase plaintiff's earning capacity, which would in turn reduce the defendant's child support obligation. And then there is some significant domestic violence between the parties in this matter. So plaintiff is requesting again sole legal and physical custody of Lauren, and for defendant to have a gradual out-of-state parenting time schedule to allow him to be reintroduced to Lauren, because right now there is no relationship. And what that might look like is defendant might come to Tucson, Arizona for the Thanksgiving break and have some parenting time on a non-overnight basis. And then plaintiff would come to Michigan possibly during the winter break to have some parenting time to reacclimate the child to the defendant. She's asking that the parties use our family wizard for communication, as well as use the calendars to help facilitate parenting time schedules. And she's requesting that the defendant primarily provide transportation for the parenting time so she can ensure that he's actually going to exercise his parenting time. And she's requesting that child support be recalculated pursuant to the form.
Okay. Okay, thank you. Mr. Wines, you can make an opening statement at this point if you wish to do so. You can reserve your opening statement or you can waive your opening statement. What would you like to do?
I would like to say my opening statement.
Okay, go ahead.
I have a few notes if I could read them off to you. I want to first off start by saying that this is not by choice. I have not abandoned my child. Never. I've never been that type of father ever in my life. This is my only child. And I've got a lot of information throughout her friends, and I have a few people in the waiting or in this meeting with me to testify on my behalf. I believe my daughter is in danger. I've heard some things about her being in a domestic relationship, and I've heard that he's been putting his hands on my daughter as well. So I honestly don't believe this is Lyric either. I believe it's whoever she's with controlling this, because I heard she's been with him for 6 years. And this stuff didn't just start happening until she was 3. So I don't agree with them moving to Tucson, Arizona. This is my only child. I do everything in my power. I pay child support. I got a job. I got a crib. or house, sorry, all of that. So I don't agree with this. I never did this by choice. This was all forced on me. I try to reach out to her. She changes her number. I don't even know where she lives. She's always know where I live. My mom and I even went as far as so we wouldn't have problems to go through third party, and she didn't even apply with that. So I have a few people in here in the room with me as well. If you want, if I have them testify.
Okay, thank you. Anything else, sir?
I have my mom here as well. No, nothing else.
Okay. Okay. Ms. Reed, you wish to
Yeah, I'm very scared for Lyric, actually. Her friend just went back to Arizona to try to find her because she knows Lyric is in danger. So I don't got nothing against my baby's mother still to this day, but this is not right. This is not fair. This is not by choice.
At all.
Okay, anything else, sir?
Could I speak?
Hold on 1 second, sir. I hear that somebody's prompting you in the background.
No,
I
my
asked-
mom. Hold
Oh,
on.
I'm sorry.
Sir,
My mom asked
I'm
if
gonna
she-
ask that you would have those people removed from the room, so when you testify and that you're only here, I don't want anybody prompting you in the background. Have them leave.
nobody can speak. She was asking, could she speak on my behalf?
I don't care about that. I've told you, have them leave the room.
Okay.
Are they out now?
Yeah.
Oh,
leave.
okay. Anything else, sir?
No, sir.
Okay. Ms. Reed, you can proceed with your proof.
I'd like to call Lyric Cannon as my first witness.
Okay. Ma'am, we're going to take some testimony from you, so I ask that you would raise your right hand and be sworn in, and then we'll proceed.
Do you solemnly swear or affirm the testimony you are about to give shall be the whole truth and nothing but the truth?
Yes, I do.
Okay. Go ahead, Ms. Reed.
Lyric, do you share one child with the defendant?
Yes, ma'am.
And is that Lauren?
Yes.
And how old is she?
Lauren is 6 years old.
And is there a current order in place regarding parenting time?
Yes, as of 2019.
Okay, and did I accurately reflect that parenting time order in my opening statement?
Yes, ma'am.
When was the last time the defendant had parenting time?
In over 3 years.
Do you recall the date and year that he had last parenting time?
Nope, not the exact date or year, but I know it's been over 3 years because I've been in a relationship for over 3 years and he hasn't been in contact.
Okay. Has the defendant ever reached out to you for parenting time with Warren?
No, ma'am.
Has he reached out to your family members for parenting time with Warren?
No, ma'am. Recently, he reached out to my brother, but that was within the last week.
Have you changed your number, your phone number?
No, ma'am. No, ma'am.
Have you blocked Mr. Wines from contacting you?
No, ma'am.
Have you changed your address?
No, ma'am.
You had heard that Mr. Wines stated that he believes you're in danger. Are you in danger?
No, ma'am. Not in danger. Me or nor my children.
Do you have any basis for knowledge where that accusation's coming from?
No, ma'am, I do not at all. My fiance does not have a domestic violence case. He does not have any domestic violence cases. Me and my kids are very safe and fine.
Has there been any law enforcement with you in the last couple of years?
No, ma'am.
Damn it.
Can you describe your relationship with Lauren?
Me and Lauren's relationship is so loving. She is sweet. She is my baby. She looks into me for comfort, for guidance. When she's scared, she talks to me. Um, she just loves me. Me and her relationship are we're so close. We bond, we cuddle, we do everything together. That's my youngest daughter. We are very close.
Okay, what kind of activities do you share with Lauren?
Me and Lauren go shopping. We have mommy and me Fridays every weekend, Monday, Wednesday, and Friday. I take each of my girls individually to spend quality time. We go to the library. We do family trips. We just came back from vacation. We cuddle. We do one-on-one time. We read together every night. I help her with homework. Me and Lauren relationship is great. We
And,
literally do everything together.
and how do you discipline Lauren?
Put her in timeout.
Is anyone else allowed to discipline Lauren?
Nope, solely just me.
Okay. Does Lauren have a relationship with the defendant?
No,
Does she know who he is?
no. She knows his name, but she does not know him, nor will she. I don't think she'll recognize him either.
Who does she view as her father figure?
My fiance, Antonio Richardson,
And how long has he been in Lauren's life?
for 4 years.
Okay. Do you purchase the items that Lauren wants and needs?
Yes, me and Antonio.
Are there any special needs for Lauren?
No, not as of now.
There's no medical, educational, or speech needs?
No, ma'am.
Okay. And you heard defendant state in his opening statement that he pays child support. Is that true?
Yes, the defendant pays $25 a month in child support, but the problem is he's inconsistent with it. Only why I know he's inconsistent because he has those causes or show hearings as far as to why he's not paying child support. I get those in the mail quite often.
Has he ever purchased or provided Lauren with food, clothing, or gifts?
No, ma'am.
Has he ever participated in doctor's appointments?
No, no doctor's appointments. No,
Has he ever participated in getting her enrolled in school?
no, ma'am. And she's attended 3 different schools.
Okay. Are you currently working?
Yes,
Where are you working?
Masashi Auto Parts
And how long have you worked there?
for 3 years.
And how many hours a week do you work?
34, between 34 and 40 hours.
And what is your rate of pay?
$22 an hour,
How many days a week do you work?
4 days a week.
Do you know what your weekly gross take-home pay is?
Yeah, I usually take home about $1,300.
And that's after taxes?
Yeah, after taxes.
Okay. Do you receive any sort of overtime pay?
No,
Do you receive any payments from profit sharing pensions or retirement?
no, ma'am.
Do you receive any military benefits?
No,
Any disability benefits?
no,
Do you receive any tips, gratuities, or lottery winnings?
no,
Are you receiving any unemployment benefits?
no.
Do you receive any public assistance like Medicaid or child care assistance?
Yes, I get Medicaid as a secondary insurance for whatever my primary doesn't cover. And yes, I get childcare because I have to go to work and I need to get my kids to school for the days that no one else can.
Okay. But the state's covering all of your child care expenses?
Yes, ma'am.
Okay. Do you have any in uniform licensing or other costs that you have to pay as a condition of your employment?
No,
If Medicaid is secondary, how much are you paying for insurance?
about $70 a month.
Is that for you and Lauren?
Yes,
Okay. Do you support any children other than Lauren?
yes, I have 2 other children as well.
And who are they?
Layla Cannon and Lamaya Cannon.
And how old is Layla?
Layla's 9.5,
And how old's Amaya?
7.
Okay. And do you currently live in a house or an apartment?
A house
And how long have you lived there?
for 4 years.
And how many bedrooms is your house?
3 bedrooms.
And can you describe the sleeping arrangements?
Yes, my kids have their room. I have my room. And then we have an extra room. Then we have a basement and they just go between if they want to sleep in this room or the other rooms. And
Okay,
the
and
basement is the play area.
who lives with you?
My grandmother.
Okay, so it's your grandmother, you, and then your three girls?
Yes, ma'am.
Okay. Do the girls have any chores or responsibilities?
Yes, every day.
And what are those?
They clean the living room. They help mommy with the kitchen when I'm done cooking. Wake up in the morning. They have to help with the breakfast in the morning. They do the bathroom with me. They do the dining room. They wipe windows. They're really good helpers.
Okay. Are there any special house rules?
Yeah, no yelling, be loving and caring, and everybody's kind to each other.
Okay. Do you have any relatives that nearby?
Yes,
And who are they?
my mom and my brother.
Do you have any relatives in Arizona?
Yes,
And who are they?
my sister and my kid's grandfather, sorry.
If your requested change domicile were granted, where would you be living?
In Tucson, Arizona.
Do you have a house prepared there?
Yes, ma'am.
Can you describe that house?
Yes, 4 bedroom, 3 bath, 2 car garage, fenced in backyard, 3-sided backyard. I live in a gated community with a swimming pool. We have a spa, access to playgrounds, parks. Um, the house is a 3-story house, 2 living room, 2 dining rooms, um, really big kitchen, all new appliances, washer and dryer in there. Let's see what else. 4 bedroom, 3 bath, another bathroom in one of the girls' bedroom. It's really nice.
And is Antonio currently renting that house?
Yes, he is.
Okay. What opportunities are in Arizona that will improve the quality of life for you and Lauren?
So the opportunities start with me first and foremost is going to school. So that is the most important thing because I'm trying to land a career. I've been working in Battle Creek at Musashi for the last 3 years, but I'm looking to make more money and stable money for me and Lauren, for all my kids actually. So going to school, finishing, having a cosmetology license will allow me to make over 70,000 a year, and that will improve our quality of life. On top of the education system, they have great education system with smaller schools and great top rated schools in the community. Also, the extracurricular activities that they offer at the university, the school itself, and throughout the community.
Okay, you said that you are wanting to go to cosmetology school. Where is the school located?
In Tucson, about 15 minutes away from the house.
And have you visited that program?
Yes, I have.
Is there any sort of financial assistance available to you for that program?
Yes, I have already been approved by financial aid, and that financial aid covers most of my tuition, or actually all of my tuition. And I also have loans coming back that I can utilize until I'm done with school.
And how long is it going to take for you to complete school?
A total of 10 to 12 months.
Excuse me, what was that?
10 to 12 months? Is that
Yes,
correct,
ma'am.
Lyric?
Correct.
Is there any sort of job placement assistance through the school?
Yes, ma'am. They place you at a job while you're still enrolled in the school. So she said at about 8 to 10 months, they start doing workshops where they have salons and business owners come in and they kind of do mock interviews to see where you're at, where do you need to be. Then they come in again towards the end of placement to choose who they want. And then if you don't get choose, they branch out to other communities and try to see where they can place you.
Is it like a guaranteed job placement or they do their best to place you?
She said it's a guarantee. She said over 98% of her students get job placements at this school. That's one of the main reasons why I've picked it.
Okay. And you had stated that you could make possibly about $70,000 a year?
Correct.
Is that more than what you're making now?
Yes, ma'am.
About how much do you make at Musashi per year right now?
Per year right now, I only make about 40,000.
And then you mentioned the schools are better in Arizona. What school would Lauren be attending?
So the school that we went to go view, we had an open house and it's called the Grazia School and it is wonderful. Like the classrooms are smaller in ratio. It's like 13 to 15 students is what we noticed. They have 2 student aides in there, teacher aides, sorry, to where if the child is falling behind or needs help with reading while the teacher is still teaching, that's great. They have extracurricular activities before and after school, free of charge, just for attending this school. They have a lot of in-community building that they have for children for them to socialize because it's so hot out there. I like the curriculum too as well because they're introducing them into STEM at a very early age, and that's exciting for me, especially for Lauren because she likes to build and get on stuff, put her hands on stuff.
Okay, and you mentioned there's some activities at the local university?
Yes, they have a robotics program, and my kids are really into building robotics. Like that's their thing. We do that at the library here at Wither Library, and so out there they have a whole program based around it, to where every break, winter break, spring break, summer break, they come and get a group of kids together, and they run a robotics program where they learn how to build robots, and they go to championships and university hosts, and it's all free.
Okay, and in living with your fiance, you would have a dual income household, is that correct?
Yes, ma'am.
And would that be a significant improvement for you?
Yes, it will.
And is your fiance currently working in Arizona?
Yes, ma'am.
Do you have any sort of criminal history?
No,
To the best of your knowledge, does the defendant have a criminal history?
no, he does not.
Does your fiance have a criminal history?
Oh, sorry. Kevin does have a criminal history. My fiance does not.
Okay, and what criminal history are you aware of Kevin?
I believe he had a simple assault charge put on his case. He had domestic violence against me, and then he had assault with a deadly weapon as well. He had a couple evictions as well on his record.
Okay. Do you use any drugs or alcohol?
No, ma'am.
Do you know if the defendant uses any drugs or alcohol?
Yeah, I heard he used to drink alcohol.
You heard or you observed?
I've never observed, but I only heard from his own mother. But other than that, that was 3 years ago, so I'm not sure prior to.
Okay. And does your fiance use drugs or alcohol?
No,
Have you ever been the subject of a Child Protective Services investigation?
no, ma'am.
Has your fiance ever been the subject of a Child Protective Services investigation?
No, ma'am.
Do you know if Mr. Wines has been the subject of a Child Protective Services investigation?
I'm not sure.
Okay. Have you ever been the subject or participated in abuse and neglect proceedings?
Have I or Mr. Wine? Sorry.
You.
No, ma'am.
Has your fiance ever been the subject or participated in abuse or neglect proceedings?
No, my fiance have not
Do you know if Tevin has participated or been the subject of abuse or neglect proceedings?
participated because he was the abuser to me.
Was this an NA case under the abuse and neglect docket, or was it just a separate matter that was handled by the police?
Sorry, you froze. I didn't get that last part, ma'am.
Was it an abuse and neglect case under an NA docket with the court, or are you talking about some other abuse?
Just and prior to me, I'm not sure about from the courts
Was it abuse of a child or an abuse of an adult?
of an adult.
Okay, so that's not like a child protective or an abuse and neglect regarding a child case, right?
Right, correct.
Okay. Were there any sort of PPOs in place?
Yes, there was. I got a PPO, I believe, in 2019 against him.
And what happened?
I was picking up our daughter. We had scheduled parenting time. This is after other domestic violence incident previously, and this was just the last straw. Went to go pick up the daughter because we had to do the parenting time drop-offs at the mediator's house, who was his mother's house, and she's staying in the Arbors in Battle Creek. Went to go drop her off. He was calling me out my name, and he reached in the back seat to put the child in the back seat. Lauren was still in a car seat carrier. My other two children were in their car seat, buckled up still in their booster seats. And he got upset at me and punched me through the back seat of the car. He punched me right in my face, right here. And through the car and park, and he ran into the house. And I drove off across the street to some more apartments, and I called the police. I stayed and waited. And when the police came, he noticed my face, he noticed the swelling, he noticed the red mark, and he said, okay, I'm gonna go get him. And within 2 days, he was arrested, and I followed up with my duty, and I pressed charges, and I got a PPO, and I did everything in my power to not let that happen again.
After the PPO was entered, had he exercised parenting time?
Yes, after the PPO was entered, I believe we were still had to do the drop-offs, and the mediator was his mother, and so I was dropping my baby off to his mom every weekend at a location that we had agreed on.
And how often did that occur after the PPO was entered?
Um, I'm not sure. It took a while because he had to go through anger management classes and everything. So I don't know the exact date. Yeah, I'm not sure of the exact date, but it was some time.
Okay. Do you have any physical issues that would affect your ability as a parent?
No, ma'am.
Do you have any mental health issues that would affect your ability as a parent?
No, ma'am.
Are you seeing any counselors or therapists?
No, ma'am.
And what school does Lauren currently attend?
Fremont International.
And what is the student to teacher ratio at Fremont?
She has 26 to 28 kids. When I drop off snacks, that's usually I drop off for like 30 kids in a classroom, and it's one teacher in there.
Does Fremont offer any sort of tutoring or teacher's aides?
No, they do not have any tutoring. They have a teacher aide in the building, but I believe it's 2 teacher aides throughout the whole building, so it's not per classroom.
Do they offer any sort of extracurricular activities?
No, the only extracurricular activities that they offer is 21st century, and that is for kids who need, I guess, childcare after school.
What is Lauren's attendance like?
Wonderful. She's always on time. You know, I have to work, so she either catches the bus or my fiance takes her to school, and she's always on time, never late.
And what grade is she going into this fall?
First grade.
And when does the school start in Arizona?
School started last week, last Monday.
Are there going to be any issues transferring her into Arizona late if the change of domicile is granted?
No, ma'am, there will be no issue. So when I was down there on vacation, I wanted to make sure if I was granted domicile that I had everything in place and that they won't lack of any schooling. And so I got it in place to where all I have to do is submit my application and, you know, the spots will still be open as long as I can apply before September.
And when does school start at Fremont?
The 15th of August.
Does Lauren like school?
Yes, she left school.
Is she currently participating in any activities?
No, as of now, she is not.
Why do you want this change?
I want this change for a better quality of life for me and my daughter. I honestly think we deserve it. We've been through a lot. I've been through a lot. And just by them being my kids, we've been through a lot over these last couple of years. And they deserve a new change of scenery and just to be around good, loving people who really care for them. And this change will help with that. The dual income household has helped me tremendously over the last 4 years. Me and my children have been emotionally, physically, mentally taken care of, financially taken care of. And we've been honestly blessed to have him in our lives. And just this move and going out to Arizona and us being a family for this vacation has showed us like what we're capable of and how it feels to just be around good people.
Have Lauren been to the house in Arizona?
Yes, yes, she has.
Okay. What is your proposed visitation schedule?
So my proposed visitation schedule is once Lauren gets to know Tevin Wines, if we can start out on the phone or on Zoom, they can see each other and she can get acquainted with his face and his voice so she knows he's not a stranger to her. And then once that progresses, I think it will be good if he can come up to Tucson and do some, like you mentioned, non-overnight visits so he can get acquainted with her and so she can feel comfortable around him. And then I can do some Michigan visits as well to where when they have a break and it works out for both of us where she can see him again, non-overnight. And then we just do that until the child gets comfortable.
Okay. And then would you propose transitioning into the out-of-state parenting time schedule?
Yes,
And are you willing to facilitate a relationship between Lauren and Mr. Wines?
yes, I am.
And you heard that he said this was forced upon him. Um, are you keeping Lauren from him?
No, not at all. I never have.
Okay. And what do you propose for transportation if the change of domicile is approved?
I propose that Mr. Wines provides a transportation means solely because he is very inconsistent with seeing the child already. It has been 3 years. Prior to this, he has been inconsistent when he put in the order first time. And so I don't feel comfortable paying for transportation in case he doesn't show up. It's been multiple times where he hasn't showed up. So transportation should be provided by him just for security.
Okay, and in our motion, we requested the use of an Our Family Wizard or Parenting Time communication app. Why do you think it's important for that application to be used?
I love that application. I love it, love it, love it. I think it's important because it allows the court to see the communication process between the two parents, and it allows to know the courts or court officials to see that communication is actually happening between the kids and the parents. There's no way to talk disrespectful or inappropriate on my wizard, and it's all monitored. And so I love the app, and it's
Have
very
you
efficient.
have you and Mr. Wines had communication issues before?
No. Actually, to be honest, I communicate through his mother in the past. I rarely communicated with him. I was communicating with her because she was the mediator. I had to meet with her for pickups and drop-offs. So I wouldn't see Mr. Wines for months, and I would be talking to his mother. So me and his communication was never very good. And
Are there
also, the mediator was put in place by the referee at the time because of domestic violence. So the court order was to not even have communication with him, with the mediator. And so I was following up with that order by doing that with his mother.
Okay. Are there any other instances of domestic violence other than what you've already testified to that put the PPO in place?
Yes, there is.
What happened and when?
Prior to that, prior to the one with the PPO, me and Mr. Wines, when we were together and we were living together in these apartments, and I was calling the police almost every week to get him out of my house. He was destroying things. We had police reports, police incidents of him, of Mr. Wines destroying the house, punching holes in the house, trashing the house, wouldn't leave the house. The police told me to evict him in order for him to leave. And I ended up having to almost get to that process, but then he ended up stealing my book bags. When I broke up with him one morning, he stole all of my books, my college books to KCC, my cell phone, my wallet, and my computer out of my car. I had a police report for that as well. And it carried all the way on to Grace Health, and it carried on because they caught him at Grace Health. They tracked my phone. They didn't catch any of the stuff on him, but he discarded of it by then. And so those are two incidents, but him destroying the house was on multiple occasions. Like I said, I was calling the police multiple times in a week to try to get him to stop. And they said he wouldn't let him leave because he was a resident of the home, because he's had a diploma there for more than 30 days. So I had to physically evict him if I wanted him to leave. And that carried on for months, for months.
And when he took your book bag and your phone, did that impact your ability to attend KCC?
Yes, ma'am. I keep everything in my school backpack, and I have my computer, my 4 classes of books, coursework in there, my wallet, and my iPhone. He took my iPhone, started texting my family members, sending them threats in a group chat, texting them, trying to fight my brother, cussing out my mother and sister. I don't know, destroyed my laptop because I never got that back. Tossed my wallet with all my ID, social security card, school ID, tossed that. Tossed the schoolwork because I couldn't finish school. Like I had to drop out of school. I was an A student and my grades dropped drastically because I didn't have any coursework, but they didn't have any resource money to provide me with any more coursework to finish the last 6 weeks of school. So I had to drop out. And fast forward to 3 years later, as of now in April of 2024, I tried to apply to KCC again. And they told me that because of the last incidents, I had to do an appeal and I had to explain the appeal to what happened. In that appeal letter, I explained to the a director and president of KCC about my domestic violence and everything I was going through at the time. And I made a police report with the KCC patrol officer at that time because it happened off of KCC's campus going into the hospital off of Harvard Street. And so they were aware of the incident, and I had to do an appeal just to get back into school to prove that I was worthy of continuing my education without any disruptions.
And were you allowed back into KCC?
Yes, the appeal was accepted.
But are you currently pursuing a degree at KCC?
No, ma'am, I'm not currently pursuing it.
Is there anything else the court should know?
Nope, not that I can think of.
Okay. I've got no further questions.
Okay. Mr. Wines, you have opportunity to ask the plaintiff questions if you wish to do so.
Who, Lyric or
Yes.
Jennifer?
No, the plaintiff.
Oh, you know, I've tried to reach out to you, Lyric.
Sir, you get to ask questions, not to make
Oh,
statements.
Why have you changed your number and made it impossible for me to reach out to you?
I have not changed my number. I have had the same phone number for 4 years. I have other kids whose fathers have been able to contact them over the years. Changed my number one time in 4 years. And I've had the same number for schools to reach me, for doctor's appointments to reach me. Me keeping the same phone number is crucial because I have children and I have appointments and I have a job. And I can't change my phone number sporadically because I have people who need to stay in contact with me for emergency contacts, for doctor's appointments, for school rides. I don't change my phone number. I have the same phone number, the same phone, the same service provider for 4 years.
Okay, why, when you seen my mom a few weeks ago at the school and she tried to speak to you, you just sporadically walked past her and act like you didn't know her? She wanted to see the kids and stuff. And we got pictures of that. So why did you do that?
Sorry, sir. I don't remember seeing your mom. I was picking up my kids from school a few weeks ago, like you said, but I don't remember seeing your mom. I'm there to pick up my kids. I don't really interact with people too much, so not sure about what you're talking about.
When did you get with your fiance?
According to you, 6 years ago, but
Okay,
that is incorrect.
Ma'am, he's not asking that. He's asking when, so answer the question.
I got with him 4 years ago.
Okay, why did you take her away from me when you got with him?
I did not take your daughter away from you. If you can recall, there was a phone conversation. You called your daughter 4 years ago. She was 1.5, and you asked to speak to her on the phone. And she started talking and she wasn't saying anything. She was saying no. And you was like, why are you making my daughter say no to me? And I didn't say anything to you. Then you called back and you heard my fiance on the phone. And sir, you told my fiance, you can take care of her. I don't got time for this. He knows that. So that was the last thing, the last conversation you had on the phone. I don't know what, I never would take your daughter away from you. You stopped seeing her. You stopped getting her. The plan was for the mediator. We were supposed to have contact between me, you, and the mediator to meet up of a place of contact. There was no messages to meet up. I'm supposed to drop her off. I don't know where to drop her off. If I don't have any communication, where am I supposed to drop her off to? If nobody contacts me, where, how do I know? Just show up at a store and hope somebody comes?
Do you know where my mom lives?
No, I do not know where your mother lives.
Okay. Do you know my mom's number?
No, I do not know your mother's phone number.
Didn't you just say y'all had recent contact when I was seeing my daughter?
Sir, that was 4 years ago. I do not have your mother's phone number. I don't have any of that.
Years.
Sorry, what was that?
Did you change your number in the last 4 years?
No, I have the same phone number.
Did you block me?
No, sir, I did not block you. I do not have your phone number. I cannot block you if I do not have your phone number.
Okay. Where do you pick my daughter up from school at again?
Fremont International School.
Right around my mom. Have you spoke with your mom?
I speak to my mom daily.
Did she tell you that I told you to reach out because she comes to my job often?
I talk to my mom daily, and no, she's never told me that. She told me that you said have Lyric call me, but I don't have your phone number, sir. My mom and her husband said that they have waited around in Dollar General on Columbia multiple times for you to come out the back with the phone number or anything. And she said you never had a phone number. She's seen you for months. Before you started making the complaints about the parenting time, she was seeing you and you never offered a phone number, as well as the times before when you were working, I guess at another store. She said that she would see you out by Dollar Tree Plaza or somewhere, and She said that she would see you and you never said anything about a phone number or asking for my number as well.
Have you tried to reach out to me?
I cannot reach out to you because I do not have a phone number.
Do you have Facebook?
I do not have a Facebook.
Do people around you have social media?
I do not have a Facebook. People around me do not have social media. And if they do, I'm not on Facebook because that is my right and I don't believe in social media.
Okay. When's the last time you actually tried to reach out to me? Do you recall even trying to?
Mr. Wines, I opposed upon the parenting time order. Me and you have a mediator because of the domestic violence. I
Correct.
am supposed to reach out to your mother. I do not have your mother's phone number. I have never once reached out to you or contacted you about our daughter. So I have not.
Okay. Well, my mom has had the same number for 18 years.
Objection, Your Honor. It's supposed to be questioned.
Okay. Go ahead,
Uh,
ask any questions you want, sir.
Okay, sorry about that. Do you ever try to reach out to my mom?
No, sir, because I do not know your mother's phone number.
My mom hasn't tried to reach out to you?
No, I have not received a phone number from your mom, a text or call from your mother.
Do you have her blocked?
I do not have your mother blocked because I do not know your mother's phone number.
I've tried. Oh, okay. Do you know I could Google your name and your addresses and your phone numbers to get in contact with you?
Attorney Jennifer Reed, this is getting confidential because of the domestic violence case. My address is supposed to be confidential, like as far as the courts.
Well, I don't have contact
He
with
hasn't asked, excuse me, ma'am, he hasn't asked for the number. I think he was asking if you have a number or
Oh,
whatever
okay.
that he could contact. He hasn't asked for it.
Okay, I'm sorry. I heard that. Sorry, Your Honor. Do I have a number? Do I have a phone number? Are you asking that? Is that what you said?
Yes.
Yes, I do have a phone number.
Do your brothers know me?
Yes, my brothers know you.
Have I tried to contact them over the years to get in contact with you?
You contacted my brother once last week, telling my brother that I was in danger and that you wanted to see your daughter. And I speak to my brothers every day, and so when he called me, yes, I was very aware of it.
Do you have a good relationship with my mom? Have you ever had any problems with her through third party?
I'm going to object to relevance.
Sir, do you want to address that? She's asking, how's it relevant about the relationship with your mother?
Because she said we go through third party, Your Honor, so we don't even have contact. So I was just trying to get this through you guys to let you know that there's never been no problem
Okay, well,
with my mom.
courts can overrule the objection. I think she has talked about the grandmother being a mediator and kind of a go-between to handle parenting time, et cetera. So I think it is a reasonable question. Go ahead.
Okay, do you want me to re-ask that lyric or
Yeah, please.
Okay. Have you ever had any problems with my mom through third party?
A few times. Sorry, what was that?
I'm gonna do one at a time.
A few times. Only issues I had was like when it was time for pickup, nobody would text me back, and that only happened sporadically. And then she would apologize and tell me, "Oh, something came up. We can do it next weekend. We can figure out another time. We can do it in another few days." That was the only issue I had with her.
Has my mom kept all three of your kids, not only my kid?
Yeah, every time I asked, not every time, a few times if I asked her, she would keep my other kids, but that's because Lauren wanted her sisters to come. Lauren would cry for her sisters, and that's how they would come.
Who took care of all three of those kids before your fiance?
Me.
I never helped take care of none of them kids. I never lived with you.
Yes, you live with me, but sir, you know you have not kept a job, and you know I've kept a job, and I take care of my kids fully to the max. I own the house, I have the car, I have the job. I financially, emotionally took care of my kids. You were a boyfriend.
So I never bought nothing for the kids.
You never bought anything for the kids.
Wow. Okay. With that being said, do you feel, how do I put it? Do you feel that you could still reach out to my mom?
Yes, I feel like I can reach out to your mom. Me and your mom has no issue with each other.
So why haven't you reached out through your mom to get to my mom? Because they know each other.
My
That's what,
mom, my mom does not hang out with your mom. My mom does not have your mother's phone number. My mom does not have any contact with you or anyone in your family, nor has she had in the past. And it has always been like that, sir. My mom has never had your mother's phone number to where they have been texting back and forth. They have never had drop-offs with Lauren. Our mothers are not friends.
do you know I still have your number? And when I call it, it goes straight to voicemail.
I
Every
don't have, that's fine, sir. I have the same phone number. I don't, I don't know, sir. I have the same phone number that I had for years. Like I said, my kids been going to the same couple schools, the same
is your
daycare. My number has not changed.
is your phone number in your name?
Why is that relevant to the case?
Is this a question?
Well, answer the question, ma'am.
No, my fiance pays my phone bill. No, my
Okay.
phone is in my fiance's name.
Does my daughter like your fiance?
My daughter loves him. She's crazy about him. She's the only man that she knows. She's known him since she was 1.5 years old.
Okay. So with that being said, why when I call your phone, don't I ever receive no text messages or calls back? My mom also, why when my mom calls your phone, she never gets a call back or nothing back?
Objection, it's a compound question. We need to ask one question at a time.
Yeah, go ahead, one at a time, sir.
Sorry about that. Why does when my mom call you, it also goes straight to voicemail?
Sir, I'm not sure. I'm not even sure how we even got each other's phone number. If you said that you were blocked and you were calling it, then you said you didn't have my number. I'm not sure what number you are even calling. You said I changed my number multiple times, and you said I blocked you. It's either I changed it or I blocked you. Either you had it or you didn't. So I'm trying to understand what you're asking me. You said I changed my number multiple times. Now you said I blocked you. If I change my number multiple times, have you had these multiple phone numbers? How are you still calling the number that you're blocked from? How are you calling a phone number that you know that I don't have?
She's asking me a question. Am I allowed to answer, or I'm just asking?
No, you're not, ma'am. You can't ask him questions.
I'm kind of confused to what he's asking me.
Well,
He's
you can say
stating,
you're confused, then don't ask him
okay,
questions. Good. Okay.
sir, I'm confused on the question that you're asking me.
Okay. Do you feel there's a problem between you and my mom, or y'all good in good standings?
Objection, it's been asked and answered, I think by this time repeatedly.
Okay. What's your response, sir?
Sorry, I couldn't hear you. Skip. It skipped.
Say what's your response to the objection about asked and answered?
Oh, I'm just trying to figure out why it's been going on so long without any communication. I get I haven't seen my daughter, but there's been no phone calls or nothing. It's just been stripped away from me, not by the courts, but from
Okay,
her.
sir, this isn't a question. Ask a question if you have it.
Do you know it's been stripped away?
I'm gonna object, Your Honor. There's somebody in that room telling Mr. Wines what's going on.
Sir, I just heard somebody talking to you. I told you to get the person out of the room.
Sorry, I'm in somebody else's house. I have to go outside.
Okay?
Okay. Sorry about that.
Well, don't let it happen again, sir, or otherwise the court could find you in contempt, or the court could again vacate and throw out all your testimony at this point.
It won't happen again, sir.
Okay, go ahead.
Do you know that I'm there for my daughter if you need me?
Um, I do not know that, sir. You have been very inconsistent in her life. She's 6 years old, and you have had multiple chances prior to this date to reach out. It's been over 3 years, and you've just started putting in complaints about parenting time. I believe you are very selfish when it comes to our daughter. So yes, I do not believe that you are there for her because you have not shown that. Also, when we worked together, you never attended doctor's appointments. Granted, she was 1.5 years old, so she was barely in the day. I was trying to go to daycare and get to go to school and everything, and you were not there. So I don't believe that.
Okay. When will, okay, I gotta make sure I put this in the right way, Your Honor. So bear with me. Have you spoke to your brother Jazel?
I speak to my brothers every day.
Has he told you that every time I see him, I ask what's going on and there's no response?
I'm gonna object to hearsay.
Okay, court will sustain the objection, sir. You can't ask what somebody else has said, okay?
I'm sorry, this is my first time going through this.
I understand. Well, when you represent yourself, you accept that responsibility to handle the case and ask questions just as if you were the attorney. So you don't get special consideration because you're representing yourself.
Okay, I understand. Have you heard from other people that I have tried to reach out to you?
I'm
No,
gonna
sir.
object again, Your Honor. It's still a hearsay issue of what she's hearing from other people.
Well,
Yeah.
sustain, sir. You can't ask her what other people are saying.
Oh, okay. So, Your Honor, I'm speaking to you in this matter. With that being, sorry. With that being said, I've only asked these questions because it's been so hard to reach out to her.
I understand why you're doing it, but it's not a proper question. So I can't have you to ask it if it's not a proper question, if it's a hearsay question.
Okay. Did you ever genuinely want me to have a relationship with Lauren?
Of course, we were in a relationship. You're her child's father. It has just been your actions over the years while we were together. The domestic violence, I could not have my daughter live with that nor see that. So that has prompted me to break up with you. And since we broke up, you have been absent from her life. I get that the parenting time order was put in place and your mother was a mediator, but it has been times where your mother was upset with you because you wasn't visiting her then. So I cannot make you be a father. Yes, I would love for you to have a relationship with your daughter. You are the one who is solely responsible for that. I have a part in it as well with being a co-parent, and I have been a co-parent. This is my third child, so I am well aware of being a co-parent. I am very well aware of what to do. You just has not exercised that in 6 years.
Do you recall our last text together?
I'm gonna
No,
object to
sir.
relevance.
Well, I don't know what the relevance is at this point, so I will allow it subject to relevance.
I'm misunderstanding, sir.
You can ask the question again, sir.
Oh, do you recall our last text together?
No, sir. I haven't spoke to you in over 4 years. I do not.
Do you have any like malice towards me?
No, sir.
Why hasn't it been so hard for us to just co-parent through third party then?
Sir, we were supposed to co-parent through your mother, and we went for a pickup one random weekend, and she did not answer the phone. And that is how it started. I have not heard anything. Nobody has reached out to me. Nobody has seen me. You have not put in no parenting time order until this last couple months. That is your right as a father to put in a parenting time order if you believe that your rights have been stripped from you. Sir, you have waited 3 years to do that. You waited until you heard that I was moving to do that. I have did everything in my power for you to see your daughter without being traumatized by being in your presence. I have been trying my best for you to have a relationship with your daughter without being brought up about the past and the domestic violence. I have done my part, my best in my ability. I got punched in the face and had to drop my daughter off to you 2 weeks later. I have done my part with your mother and you.
Your
I
Honor,
have tried my best.
I have a question. Your Honor, Brian Kirkham,
Yep.
sir. When she's going too far in depth, do I just gotta sit there and listen?
Well, if it's not responsive, you can always object to the responsiveness of the question.
I object to that.
Okay, well. Okay, so we'll wait for that now. She's already done it, so in the future you can object. Go ahead.
Do you know you could contact me anytime?
Upon the parenting time order, sir, I believe a third party is in the best interest, and that is what the order was put in place. And I believe in following the rules, so I will follow what the order says.
Why hasn't the third party been contacted in
I'm going
years?
to object again, Your Honor. This has been asked and answered repeatedly, and my client has testified repeatedly. She does not have Mr. Wine's phone number. She does not have the mediator's phone number or his mom's phone number.
Okay. She has answered it before, sir, so move on, please.
Okay. Do you plan on letting me have a relationship with Lauren?
Yes, sir, I answered that question previously.
I don't believe so, but okay. Do you feel like I have a fair chance at being a father in this situation?
I believe if you try to be a father, you can. That's the only answer I have. If someone wants to see their child, they have to put in the efforts. That's it.
Is
There's
your
no
fiance
trying when being a parent. You have to do it.
hindering me from seeing my daughter?
No, sir. It hasn't. No, no.
And you said you've been with him. Oh, it's not a question. Sorry. You've been with him for 3 years, right?
Objection.
years.
That's been asked and answered.
It has been.
But I'm getting this all gets me to my point that I'm trying
Well,
to get.
she's already answered the question though, so you can't just keep asking a question over and over. Or she answered that question with Miss Reed too, so. Move on.
Okay. Why do you feel like taking my daughter to Arizona will help build any relationship?
Honestly, you have not seen your daughter in over 3 years. So the relationship that you have with your daughter is none. You have not contacted the courts in over 3 years, nor me in regards to having any relationship with your daughter. So I took it as you did not want to have a relationship with your daughter. I have moved on with my life and I am engaged and I have made plans with my future husband and my kids because you were absent. You have abandoned her. So I had no acknowledgement.
Okay, hold on, ma'am. Please file it. He said object. What's the objection, sir?
That didn't answer my question.
Well, she stated that basically that you have not had contact, etc. So I guess that's sufficient. Ask your next question.
Okay. That's all I have.
Okay.
Your Honor,
But
uh, I have people in the room willing, which is her willing to testify for me.
okay, well, that's fine. It's not your turn yet. Miss Reed has to present her witnesses. And when she's
Okay.
done, and I will tell you, as I said before, they shouldn't be in the room with you.
Okay, they said they in the waiting room, I guess. So.
Okay, that's fine. Then when it's your turn, you can have them testify.
Okay.
Ma'am, you had mentioned that originally, you said that your insurance would run you $70 per month. Are
Mhm.
all three of your children on that?
Yes, sir. They take money out of my check weekly and it goes towards my insurance.
Okay, that's not what I asked. I knew they would take it out. I was just asking if there were three children on that. So there's three children and you, so there's four people on the insurance.
Correct. Yes.
Okay. You had mentioned a figure that you said you thought you'd be able to make over 70,000 a year once you have your cosmetology license. Where did you get that number from?
The school, they said that based off of the average salary in Tucson and the demand, that it's possible you can make that or above, depending on the rates that you offer and the services that you provide.
Okay. I didn't catch, you had mentioned that that the defendant had a criminal history, and you went really quick through what those were, and I didn't catch them all. Would you kind of tell me what they were again, if you're aware?
Yeah, I'm sorry about that. Um, he has a domestic violence case against me. He had a simple assault as well. He had
Hold on,
a
hold on. Was the assault with you or someone else?
with me. That was when he punched me in the face.
Oh, that was out of the same incident then?
Yes, sir.
Okay, so we had one case there, which was
Mhm.
domestic violence and assault. What other
Yes.
cases?
He had a separate case that was, I believe, assault with a deadly weapon.
And how are you aware of that?
Speaking to my attorney, Miss Jennifer Reed, we looked it up while trying to see what all we needed as evidence for this case
Okay.
and to get the date on the exact order that I had.
Anything else?
I believe he had eviction
Okay,
on his record, but that
I'm
was
just
it.
looking for any criminal actions.
Okay.
Okay, I don't have anything further. Anything else, Ms. Reed? Any redirect?
Yes, Your Honor.
Okay.
Lyric, you had mentioned some parenting time complaints that were filed this year by Mr. Wines. Is that correct?
Yes, ma'am. Correct.
How many parenting time complaints has he filed?
I I believe 4 or 5 almost every weekend.
Did we have a show cause hearing on some of those parenting time complaints on July 9th?
Yes, ma'am.
Did Mr. Wines appear at that hearing?
No, he did not.
Were those dismissed because he did not appear?
Yes, ma'am.
And do we have another show cause hearing coming up towards the end of this month on additional parenting time complaints?
Yes, he put additional parenting time complaint after he didn't show to the one on the 9th, and now we have another cause hearing. Yes.
And he has not filed any other parenting time complaints in the last 3 years.
Correct. Yes.
But he knows how to, correct?
Yes, he does. Correct.
Have you kept your address up to date with friend of the court?
Yes, ma'am.
Mr. Wines is questioning you of why his phone calls went straight to voicemail. Have you received any voicemails from Mr. Wines or his mother?
No, ma'am.
Have you received text messages from Mr. Wines or his mother?
No, ma'am.
I have no further questions.
Okay. Sir, any, as a result of my question or Ms. Reed's redirect, do you have any recross?
I just need to know what I can do, sir. This is my first son, and what I can't.
Okay, as again, you accept that responsibility, so the court's not gonna give you special consideration because you choose to represent yourself.
I'm allowed to ask questions.
You're allowed to ask questions relating to any of the questions I asked or that Ms. Reed asked on redirect.
Okay. So, no, nothing. I ain't got nothing to say on that. But I don't know how to. I just learned how to file complaints. Like I said, this is my only child.
Okay, sir, that's not a question.
All right, no questions.
Okay, thank you. Ms. Reed, any additional witnesses?
Yes, I'd like to call Antonio Richardson. It's my understanding he's in the waiting room.
Okay,
Yes. You bring.
Hello.
good morning, sir.
Good morning.
What we're gonna do is, we're gonna ask you some questions, so I ask that you would raise your hand, be sworn in, then we'll proceed.
Do you solemnly swear or affirm the testimony you are about to give shall be the whole truth and nothing but the truth?
Yes, I do.
Okay, go ahead, Ms. Reed.
Good morning, Antonio. Can you hear me?
I can hear you.
What is your relation to the parties in this matter?
Lyric is my fiance, and Lauren is my daughter.
Is she your daughter or is she Mr. Wines' daughter?
Mr. Wines is her biological father.
Okay. And how long have you been dating in a relationship with Lyric?
About 4 years.
Okay. And can you describe your relationship with Lauren?
My relationship with Lauren is good. That's my baby. We get along fine. We do a lot together. She FaceTimes me when I'm at work. She'll give me hugs, tell me I love you all the time when I come home. We just do a lot together. Showed her how to ride her bike. We do a lot of family vacations. Take her to different zoos, museums. We just do a lot. We do a lot together. Me and the other as a whole family.
Where do you currently live?
Tucson, Arizona.
And how long have you been there?
About 8 weeks.
Okay. And are you currently renting a house?
Yes.
Can you describe the house for me?
I have a 4-bedroom, 3-bath, bi-level, privacy fenced in backyard, 2-car garage, 2 central air units, 2 living rooms, fireplace. Anything else?
That's fine. And is the 4-bedroom house in preparation for Miss Cannon and her daughters to move in with you?
Yes, it is. I'm waiting on them. Yep.
And are you currently working?
I am.
And where are you working?
At a barber shop in Tucson.
And how long have you worked there?
It's about a little over a month.
And based on your current clientele and what you've been making over the month, and on the general income of other barbers in your shop, what do you predict your gross income to be this year?
Um, Averaging them anywhere from 8 to 10,000 a month.
So you're looking at maybe $80,000 to $100,000 this year?
Yeah,
Are you willing to support Lyric and her children?
I am. I have been for the past 3+ years. So yeah, I'm definitely ready for that.
Do you have any criminal history?
I do not.
Do you have any children protective services history?
I do not.
Have you ever had any court proceedings regarding abuse and neglect of any children?
I have not.
Is Lyric currently in any danger?
No, she's not.
Is Lauren currently in any danger?
No, she's not.
Are you in any way restricting Lauren's ability to visit Mr. Wines?
Not at all.
Are you willing to facilitate a relationship between Lauren and Mr. Wines?
Am I willing to facilitate a relationship? Yeah,
Yes.
for sure. For sure. I personally haven't ever even seen this man. I haven't ever seen him in Lauren hasn't seen him in over since I've been around. So I don't even know what he looks like. So it's hard. Yeah, facilitate relationship. Yeah, I don't even know this man. But
I have no further questions.
Okay. Mr. Wines, you have opportunity to ask, Mr. Richardson some questions if you wish to do so.
Mr. Richardson, do you have any kids?
yep,
Do you have close relationships with those kids?
I do.
Why do you make it hard for me and my daughter to have a relationship?
How do I do that?
He's asking me a question, sir. I'm allowed to.
I understand. Just, Mr. Richardson, you can't ask him questions. You just answer the question if you can.
I don't have an answer for that because I don't do anything to stop that. So it's
Okay. And that's your answer.
Do you physically discipline my daughter?
no, I don't.
What's your occupation?
I'm going to object. That was asked and answered by myself. Mr. Richardson works as a barber.
Well, you just okay. I'll allow him. Go ahead and answer the question, sir.
I'm a barber.
You've never seen me before?
I have not.
You've never seen me at Phase One Barbershop before?
I have not.
Did you used to cut hair with Mitchell?
Yeah,
So you have. Okay. Has my daughter ever asked you to call and talk to me?
never.
Objection. It's hearsay.
Sustained.
Do
Right.
you tell Lyric to reach out so her and her dad can have a relationship?
I don't understand the question.
Are you hindering?
Go ahead.
Me.
Maybe you could rephrase it, sir.
All right. Are you hindering anything from me and my daughter having a relationship?
Not at all.
Do you recall seeing my aunt? Do you know Crystal Wines?
I do not.
Do you recall seeing Crystal at Dudley and telling her she couldn't talk to my daughter?
I do not.
Lyric, do you oh, is this only for him?
Yes.
Oh, okay. What type of relationship do you have with Lauren?
I'm gonna object. That was asked and answered.
Well, specify, sir, again, he's talked about being engaged and them having again, that relationship for almost 4 years, so maybe if you have specific questions.
Do you discipline any of the other kids?
Is this about Lauren or I don't know what to do.
Yep, he's
About-
asked about the other children that presumably the plaintiff has.
No,
Do you know Malika?
no, I don't.
Has she tried to reach out for me to get in contact with you guys?
I don't even know who Malika is. No, Malika has contacted me.
Do you have contact with your son?
What?
Do you have contact with your son?
Do I need to answer that? Is this
Yes,
about
sir.
Lauren? Okay, yeah, I do.
Has he told you I've reached
No,
out
he
to
hasn't.
Objection, hearsay.
Sustained.
How do you discipline my daughter?
Objection, asked and answered.
Yeah, sir, he's testified that he doesn't discipline your daughter, so.
Okay. Do you transport my daughter to school?
Every day for the past 3.5 years. Also the doctor's appointments, also the conferences, also the extracurricular activities, also to the Y Center, also to karate class, also to soccer.
Good. Do you want my daughter to have a relationship with me or not?
I don't have an opinion.
Okay, that's all I have.
Okay. Anything else, Ms. Reed?
No, Your Honor.
Okay, thank you. Thank you, Mr. Richardson. That'll conclude your testimony. You're free to go. Have a good day.
Thank you, you as well.
Ms. Reed, next witness.
I have no further witnesses.
Okay. You rest.
Yes.
Okay. Mr. Wines, now's your opportunity to present your witnesses, if whatever you have.
Malika Linwood.
Okay.
Yeah. All right.
Ms. Linwood, you're muted. You have to unmute and join the visual. Okay. Are you able to hear us, ma'am?
Yes.
Okay. What we're going to do is we're going to take some testimony from you. So we'll have you raise your right hand, be sworn in, then we'll proceed.
Do you solemnly swear or affirm the testimony you are about to give shall be the whole truth and nothing but the truth?
Yes.
Okay. Go ahead, Mr. Wines.
Sorry, I couldn't hear you. Skip.
So go ahead, Mr. Wines. You can ask your questions now.
Malika.
Yeah.
Hey. Have we recently spoke, correct?
Yes.
And you told me that you have been in contact with Lyric.
I'm gonna object to the form of the question he's leading.
Okay. Sir, what you do is you can ask her if she's had contact with the plaintiff, et cetera. You can't lead a person, so you can't effectively
Okay.
you can't effectively tell them what you want them to testify to, okay?
Have you had contact with Lyric?
Yes.
When's the last time you spoke with Lyric?
It had to been, I want to say my visit, it had to been about a month and a half ago.
Okay, who is Lyric to you?
Lyric, I consider lyric as my day one, and let me give y'all that definition. Every morning, every night for years next to each other, as a friend, a best friend.
Okay. Have you saw Lyric and the kids anytime recently?
The last time I saw Lyric with my eyes, like in person, was 5 years ago, my daughter's birthday, and she was only allowed to stay about 5 minutes or so, and I've very rarely been able to stay in contact since then.
Is it hard to reach Lyric?
It's mostly impossible. You know, or she reaches out when she can, and that's rare.
How does she reach out to you?
I'm gonna object to relevance.
Uh, and I don't want to say that
Hold
anyway.
on, ma'am. Ma'am, if there's an objection, you need to stop and let us figure out the objection.
Okay.
How is this relevant, sir?
I'm trying to figure out how she connects to everybody else, because through phone it doesn't work for me.
Well, okay. Her contacting and how she reaches out to everybody else isn't relevant to how she may reach out to you or.
Okay.
So if you could ask them specific questions as it pertains to you, then that would be fine.
Okay. So you said when's the last time you seen her? Sorry. Like 5 years?
August 15th.
Okay. When you spoke, what did you guys talk about?
Objection, hearsay, and relevance.
Okay, how's that relevant, what they might have said 5 years ago, sir?
It was.
Ma'am, hold on.
It was.
Ma'am, stop talking.
Years ago.
There's an objection. If there's an objection, you need to stop talking so that we can work out the objection. Okay, sir, how is it relevant what they talked about 5 years ago?
Well, she's talked to her recently. She just said,
Well, she said she last saw her. Okay, she did talk about a month and a half ago, but how is that relevant to this case?
to tell you that my daughter is in danger.
Okay,
Like,
well, you need to ask questions pertaining to that as opposed to ask just general. I mean, they could have talked about the weather. They could have talked about any myriad of things.
Malika, we have no relationship outside of this case, correct?
Yes.
I'm gonna object again, he's leading.
Well, I'll allow it. It's kind of preliminary to, again, the testimony, so I'll allow it. Go ahead.
Yeah, we have no relationship outside of this case, correct?
Right.
Did you reach out to me concerned about Lyric?
I did not reach out to you. About 2 weeks ago, I was visiting Michigan and I ran into you, remember? So I asked you, have you spoken to Lyric? And I asked you, have you seen your daughter? Because my friend is in danger and she has been in danger for 5 years. And I was trying to see
Objection.
if you have been in contact with her because I'm not aware.
Objection.
Okay. Hold on, ma'am.
Like,
Again, there's an objection, so stop speaking. Okay, what's your objection, Miss Reed?
Well, there's multiple issues. We have lack of foundation for the allegations of danger when there's already been testimony there hasn't been contact in over 5 years. And we have some hearsay issues as well as some relevance issues of what's going on.
Okay, well, I guess we need to have more to ferret out the objections on that, so. Sir, if she's saying that, again, that the plaintiff is in danger, you're gonna have to establish a foundation as to how she knows and what that might be.
Okay. How do you know that Lyric is in danger?
from Lyric herself. I can't tell you a specific day, a specific conversation or phone call, or even a phone number, ladies and gentlemen. But throughout the years, I have been speaking to my friend before she left or, was captured. I have been speaking to her. I know about her situation. I am one of her best friends. Okay. And she cannot help herself.
Objection calls for speculation. And there's still lack of foundation about the allegation of being captured and that she can't help herself.
Okay, well, court will disregard that. We're talking, she says she's in danger and she's found that through speaking to the plaintiff. So allow her to go into that. She just set a foundation for that.
Yeah, right.
Miss Malika, what did Lyric tell you when you spoke to her to make you concerned?
Well, I've been gone and residing in Arizona for about 5 years. That's like I said, that's the last time I seen her physically. But for about 6 to 7 years, I want to say a solid 5 years. You know, the year prior to that, the whole year, you know, we would be able to meet up in person when she was able to run an errand or do something in her life. Like she would get like an extra 3 minutes. We would be able to connect in those times. But it was very short, and I was just, you know, it was a welfare check and a hug to make sure she was okay. And then I wouldn't see her for another year after that.
Do you feel like my daughter is in good hands being around her fiance?
No.
Objection calls for speculation.
Okay, I'm answering the question.
Okay, ma'am, again, if somebody's objecting, you have to stop talking. Okay? Because we have to figure out the objection before we can take your answer. We may bar you from answering that particular question. So what is the objection, Ms. Reed?
It's speculation, as she's testified that she hasn't seen my client over 5 years. How can she testify to if the child's in good hands?
Okay, well, maybe Mr. Lyons, you'll need to discern that and set a foundation for how she can answer that question.
Malika, how could you say these things and you haven't seen her in 5 years?
Well, when I refer to a lyric as a day one, and we go from every morning, 8 in the morning to 10 o'clock at night, every day for years, I did mention that, right? Did everyone hear that? So if she goes from my day one, and then, you know, I move into a whole nother state, I see her a year or two prior, almost every other day, almost every week prior, and then it goes from that to once a week, to once a month, to once every 6 months. My friend is in danger is what I speculate.
Objection, there's still
Okay.
speculation.
Okay, again, the court will sustain the objection at this point. You need to set a foundation. Just because she is not having contact
Okay,
doesn't mean someone is in danger.
okay. In what ways do you believe Lyric is in danger?
My personal belief, or do I need facts on this?
Kirk,
Um,
sir?
my personal belief is um physically, I have seen bruises on her, though, you know, when we talk. I'm not going to tell you guys how we talked. It's been 5 years since an in person. Can everyone hear that? Since in person. I've been on video, I've been contacting her, calling her ever since then. It's bruises on my friend. I used to be able to speak to the kids. I can't speak to the kids. I can't see my friend or her babies. I don't feel like something is right because she can't freely call me.
Objection calls for speculation.
4th of July.
Sustain. Ma'am, again, when the attorney objects, you need to stop talking.
Right, sir, I didn't hear it.
Okay, that's fine.
Because I was in a sentence and she said it.
Okay,
So sorry.
okay. Court will sustain the objection. Go ahead, move on, Mr. Wines.
The last time you seen Lyric, how did that altercation go?
The
I'm gonna
interaction.
object to relevance, as the last time the in-person contact was made was 5 years ago.
Well, she did state she has seen her on Zoom, so that may set the foundation, sir, as to when you talked the last time. Are we talking the 5 years ago? Are we talking, you know, some other time in which it was on Zoom? So maybe clarify what you're talking about.
Okay. When's the last time you've seen Lyric? That's the best I can.
Okay. The last time I seen her on video, okay,
Yes,
not in person. The 4th of July, not the 4th of July, it must have been a week before that. She said that we can hang out and get together, and it'll be a little family trip. And I was already kind of a little sus about that, but I'm like, okay. But that, you know, that's the last time we were able to speak. So I've been I've been messaging her ever since the 4th of July, like the week prior to 4th of July, all the way up until this morning, yesterday, the day before yesterday.
Okay,
And
ma'am, just to clarify, are we talking what year of the 4th of July?
this is 2024, 4th of
Okay,
July,
thank you.
a month ago. And these past, every other day or every 3 days, maybe, I am contacting her and she's not getting back in contact. Let's put it like that. But I don't think she's able to.
Okay,
Objection, speculation.
sustained. Go ahead, Mr. Wines.
Okay, I was just making sure we are clear. Do you believe not only Lyric is in, let's say, not in good hands, do you believe the kids are okay?
I'm gonna object, it's a speculation again.
Sustained. There's been no foundation laid for the question, nor is she able to testify to that.
Okay. How did the last altercation go with you and Lyric when you seen her on video?
She looked a little scared. Well, with my eyes and how I know my friend for over 5 to 6 to 7 years, looking around, trying to make sure her surroundings are clear and safe so that she can whisper the couple of words that she was able to whisper. My friend, I never seen her like that. So I believe personally, with my speculation, my observations, that, she was looking scared and frantic. Do you guys know what frantic means? I don't think that she was like freely able to be on the phone with.
Objection, speculation.
Okay, sustained.
Malika, do you believe I'm a good father?
Yes, I have seen.
Objection, lack of foundation.
Okay, sir, you're gonna have to establish why she comes to that opinion.
You said what?
Again, she's objected to speculation, so you're gonna have to establish how the witnesses come to that opinion, because otherwise it's speculative without a foundation.
I'm misunderstanding.
I can't help you, sir. I've explained that.
All right. So have you spoke to Lyric since for the last encounter?
No.
You have tried to reach out, you said?
Yes.
There's been nothing said back?
No.
Does Lyric reach out to you just as much as you reach out to her?
No. It's about she reaches
I'm
out
gonna object to relevance.
a year.
Okay. Sir, what's the relevance of whether the plaintiff reaches out to her or not?
The relevance is because it's been impossible for me to get in contact. So I was wondering if she is keeping a close,
You need to explain to them how you feel. Like,
Ma'am, hold on.
explain to them how you feel.
Ma'am, hold on. Okay, well, I'm going to sustain the objection. I don't think it's relevant as to an inference, if you would, if she's having difficulty contacting someone else as to contacting you. So move on. If Miss Linwood is still there, I don't know.
I'm still here.
Okay. Go ahead, Mr. Wines.
I don't even know what questions I could ask. It seems like when you spoke to Lyric the last time, when you spoke to Lyric the last time, did you guys plan anything?
Yes, we did. We planned.
I'm gonna object to relevance. I don't see how any of this is relevant to this current case.
Well, you're going to have to explain, and Mr. Wines, again, have her establish why it's relevant and whether they made plans for anything.
Okay, we just on to the next question.
Go ahead.
Malika, do you know anything about Lyric's fiance?
We have mutual friends, and They're all considered day ones. I'm not speaking on any names specifically. We are all females. We all know who we date and when we all started dating these people. I'm not familiar with his full actual name, but I know exactly who he is. And all of our friends and our clique know who this man is as well. Ever since she started dating this man, she's, it's been different. Let's just say that. So I don't get objective. It's been a little different. And he's a dangerous man. He's known on the streets for being.
Objection, lack of foundation.
Sustained. Sir, you have to lay a foundation if somebody's going to make a statement.
Okay. Okay. Do you believe he's dangerous?
Okay,
Yes.
Objection, speculation.
that's not laying a foundation, sir.
Okay. Do you believe he has my daughter's best interest since you do know him?
Objection, that's speculation again.
Being sustained.
Well, he obviously don't know how to
Ma'am,
actually.
no, don't talk. Go ahead, sir.
Malika, do you plan on keeping a close friendship with Lyric?
Objection, relevance.
Sustained.
All right. Have you ever met my daughter, Malika? Lauren Wines?
Yes.
How was that interaction?
They it was kind of like, I know a kid. I have three children myself. So, the fact that I meet them, at the birthday party, they wanted to be happy. They wanted to be kids. They wanted to enjoy themselves. But for them to only be attending a birthday party for 4.5, 5 minutes, they kind of got really, really sad in the face on the way out the door. Lyric, her eyes were watering like she wanted to cry. Like, I don't think that that it was happy times inside. They just, faked the funk.
I'm
Just
gonna object. I don't see how this is relevant.
Yeah, how is it relevant, Mr. Wines?
tell them what you need.
Yeah, I'm just trying to get down to the point of,
Can I talk for like 2 seconds or no?
Ms. Linwood, you need to stop talking. Go ahead, Mr. Wines.
I just want to be an active father, and
Well, that's fine, but it has nothing to do with this witness as to whether you want to be an active father. So ask the witness relevant questions and we can move this matter along.
yeah. Can you hear me?
Yes, I'm here.
Okay. Can y'all hear me? Or is it
Yes.
skipping? Okay. When you guys talked, did you sense the same person that you used to know?
Objection calls for speculation and a sense, and I still don't understand how this is relevant.
Sustained.
I don't even know what to ask. All right, that wraps it up pretty much.
Okay. Okay, thank you. Ms. Reed, do you have any questions of the witness?
I do not.
Okay. Ms. Linwood, that concludes your
Lyric,
questioning. You're free to go. Have a good day.
I love you.
Goodbye. Next witness, Mr. Wines.
Brandon is my next witness. He should be in the room.
Brandon?
Yeah.
Brandon what?
I'm not sure of his last name. He's in the waiting room though, he said.
I don't have anybody in the waiting room right now on Zoom here.
Yep, there's no one in the waiting room now.
Okay. All right. Well, that's my only witness then.
That's your only other witness?
Yes.
Okay, and that person's not here, so do you rest, sir?
Yes.
You have no more witnesses, correct?
No more witnesses.
Okay, thank you. Ms. Reed, do you have any rebuttal witnesses?
I do not.
Okay. Okay, looks like that concludes the proofs. And Ms. Reed, do you have any closing argument to make?
I do. So Lyric's requesting sole legal custody because there's been swearing and apparently apparent based on the testimony communication issues, and there's been domestic violence, there's been PPOs, and she believes that she cannot co-parent, and it's been demonstrated there's a co-parenting issue regarding this child. So she's requesting sole legal custody so she can make those sole decisions for the child. She has been making the sole decisions for the child, and it's been testified that Mr. Wines has not been active in this child's life for the last 3 years. The big question is regarding the change in domicile request. First, the trial court again must determine whether the moving party has established by a preponderance of the evidence the factors enumerated in MCL 722.314. Number one in that analysis is whether the legal residence change has the capacity to improve the quality of life for both the child and the relocating parent. And I believe Lyric has met that burden by clear and convincing evidence, not necessarily by a preponderance. She has testified that this move will offer her an ability to attend a school for beauty to get a cosmetology license, where she's going to be able to have some grant funding or some financial aid to help pay for the majority of that school. Upon completion and during that school, she's going to be able to have almost guaranteed job placement in location that she has an opportunity to make almost double of what her current income is. She's also testified that this move is going to have the ability to improve both the life of herself and her child by that one increase of income, but also that there is an increase and a better school environment in place for Lauren with a lower to student teacher ratio, with ability of 2 in-classroom teachers' aides, with some extracurricular activities focused around STEM offered for free by the local university, as well as the improvement in their living situation of a larger house in a gated community with a pool and other opportunities available within that community. So that's a very clear life improvement for both Lyric and the child. The second factor is the degree to which the court is satisfied if the court, I'm sorry, I moved on to the third one. The second factor is the degree to which the parent has complied with and utilized his or her time under the current court order governing parenting time with the child. It's been clearly established that through testimony that Mr. Wines has not had parenting time or exercised his parenting time or even sought to exercise his parenting time in the last 3 years. Only when he found out that Lyric was planning to move did he file parenting time complaints. One of those we went to a hearing on. Mr. Wines did not appear. The referee dismissed that parenting time complaint because he did not appear. So he has not complied with the parenting time order. The third factor is the degree to which the court is satisfied the court permits the legal residence change. It's possible to order modification of the parenting time schedule or other arrangements governing the child's schedule in a manner that can provide an adequate basis for preserving and fostering the parent's relationship with the child and each parent. Right now, Mr. Wines does not have a relationship with his daughter. His daughter, as Lyric has testified, does not know who he is and looks to Mr. Antonio Richardson as the father figure, as that who's been the primary father figure throughout her entire life, at least for the last 4 years. That's who she looks to for love and affection, as well as her mom. And she's going to need some time to get to know Mr. Wines. And my client has testified that she's willing and able and will facilitate that relationship, but she does believe there needs to be a slow process of reintegration and that she's willing to do the parenting time through the winter breaks and the spring breaks and the fall breaks to try and reintroduce that. So maybe the summertime parenting time next year is not as such a shock when she does not know Mr. Wines. The next factor is the extent to which the parent opposing the legal residence change is motivated by a desire to secure a financial advantage with respect to a support obligation. There has been no testimony regarding that factor, but I have stated, and I believe my client has stated with her, going to school with the potential of making about $70,000 a year and up, that would reduce Mr. Wines' child support obligation as it almost doubles her income. The next factor is the domestic violence, whether that violence was directed against or witnessed by the child. My client has testified that there was domestic violence in the presence of the child that resulted in a PPO and potential some criminal charges for domestic violence and assault. Once the court looks at the factors under the domicile statute, second, the court must look at if the factors support a change of domicile, then the court must determine whether an established custodial environment exists. We would present that the established custodial environment is clearly with plaintiff, as defendant has been absent for the last 3 years. And the child looks to plaintiff and Antonio Richardson for love, affection, guidance, needs of daily living. And that has happened over the last 3 years, which is an appreciable time. Third, if an established custodial environment exists, the trial court must then determine whether the change of domicile would alter or modify the established custodial environment. And it does not, as the established custodial environment would remain with plaintiff. And then finally, if and only if the trial court finds that the change of domicile would modify or alter the established custodial environment, must the trial court determine whether the change of domicile would be in the child's best interest, considering the best interest factors. Now, we were also requesting a change in parenting time, so we went through the best interest factors, and we believe that all of those factors favor plaintiff, as plaintiff shows the child love, affection, guidance, needs. Plaintiff has the capacity to show the child love, affection, guidance, and provide for her needs. She has the ability to provide for her financially. And while we believe that the defendant has the ability to provide for her financially, he has been subject to multiple show causes for failure to pay a very minimal amount of child support. He has not provided her food, clothing, gifts, or any sort of other support, and my client has not had contact with him for the last 3 years. There is domestic violence. There is a severe breakdown of communication, as has been repeatedly testified, which is why it's important that we have a communication app. So we're not running into let's contact everyone and everyone's family to try and get a hold of somebody. It can be all through our family wizard. It has the red receipts on there. It has the calendar so we can track parenting time. And we're not trying to petition the community, as it were, to try and get a hold of an arranged parenting time. I believe my client has met her burden to change domicile, and I believe she's met her burden to change legal custody. And we're requesting that she have sole legal custody, so that she be permitted to change domicile to Arizona, that we have a graduated out-of-state parenting time schedule to reacclimate the child with the defendant. That would include Zoom calls, video calls, and I do believe our family wizard, if they pay an additional amount, might offer also some sort of communication, but Zoom and maybe FaceTime or Skype is free. And then child support calculated under the formula.
Okay, thank you. Mr. Wines, your closing argument.
My closing argument is that my main concern is that even with that being said, that she said that we are going to go over, I don't believe I have any contact with my daughter whatsoever, if that's the case, because I've been trying to reach out for Lyric for 3 years, and she constantly changes her phone number. I never even knew where she lived. She's always know where my family stays. She's know where I stay. She used to drop my daughter off, but she's never made it clear where she is or her number. She changes and blocks my mom.
I'm going to object, Your Honor. He's testifying to evidence that was not offered into evidence, and now he's testifying during a closing.
I understand. It's a closing argument. The court will disregard any argument that isn't satisfied or substantiated by the testimony.
Good. Tried to reach out.
Okay. We're getting some interference. Is somebody talking in the background?
Lyric, can you mute yourself?
I'm sorry, yes. Sorry.
Okay. Okay, go ahead, Mr. Wines.
I've been trying to reach out for Lyric for the whole time, and me and Lyric, we used to have times where, I would see my daughter, and then she'd go like a week without seeing my daughter, and then she'd reach out. So it was, and I've always been a selfless dad. I'm not the type of dad to where if my daughter doesn't want to be with me, she can be wherever she wants. I'm a selfless dad when it comes down to it. So always made sure that I've tried to keep contact with my daughter. I have been trying to reach out to Lyric, and I wasn't sure on how to go through the courts. I had to learn everything by myself. So yeah, that's why I started putting in the complaint, because I learned how to do it myself over time. I am attending school, KCC, for my trade this fall. I am working right now. I have a shelter for my daughter. I'm building right now for me and my daughter. So I don't feel like her moving to Tucson, Arizona will help me and my daughter build any type of relationship whatsoever, because it's been hard over the 3 years to contact Lyric to continue building that relationship with my daughter. So I ask that the court, be considerate of my feelings and me and my daughter's relationship. That's it.
Okay, anything else, Ms. Reed?
No, Your Honor.
Okay, thank you. Well, in this particular case, the court has heard the testimony in this matter. The matter is before the court on the plaintiff's motion to modify legal custody, parenting time, support, and change of domicile. So we have all of those issues. The court notes that the final judgment in this case was from September 27, 2018, and that was subsequently changed on September 17, 2019. In that order, that was order regarding custody, parenting time, and support. It provided primary physical custody to plaintiff, joint legal custody, and parenting time every Saturday from 12 o'clock until Sunday at 6 o'clock p.m. Again, that's from 2019. There was a period of time when the parties had provided for some parenting time in this particular matter. The testimony has shown that happened maybe for a couple years, and that was sporadic to some extent, and the parties, because of the domestic violence case and the charges in that matter, that they had to use the paternal grandmother as stated as a mediator, but I'd say as an intermediary in this particular matter. The court will note, and I'll address the issue of custody first in this case. The plaintiff is asked for sole legal custody. She already possesses sole physical custody. And the court will look at the statute as the joint custody, and that's MCL 722.26A, and that provides that in custody disputes between the parties shall be advised of joint custody. They're obviously aware of that because they do have joint legal. And court will look at in this particular matter to determine whether there should in fact be joint custody. The court has to consider the best interest factors, and I'll address those in a moment. In this case, the statute provides under subsection 2, it provides that court can grant joint custody if the parties agree on joint custody. The court shall award joint custody unless the court determines on the record, based upon clear and convincing evidence, that joint custody is not in the best interest of the minor child. The question under subsection B is whether the parents will be able to cooperate and generally agree concerning important decisions affecting the welfare of the child. In this case, it's clear that, again, at least the parties, there was not much, if any, testimony as it related to the time prior to the 3+ years that there's been no contact. But even before that, there was testimony that the defendant was not involved in doctor's appointments for the child, He was not involved in school enrollment. He was not involved in, again, other school activities. And there's been no testimony to the fact that he has in this particular matter. So it does appear, based upon a total absence of involvement by the defendant, that he has abdicated those responsibilities and that to the plaintiff in this particular case. As a result, the court does note, it appears that she has in fact provided solely for the child during that 3+ years without any involvement of the defendant. He will state, as he has, that it's because he's been, again, the plaintiff has not involved him in those decisions. She has not reached out to him to discuss things with him. But again, communication is one of those things that you probably can't simply look at and say, well, it's this person's fault. I mean, communication is a two-way process. And if the defendant wishes to have communication, he needs to initiate, he needs to be able to seek to enforce that. And in this particular case, as the court looks back through the file, no time during the 3+ years has the defendant ever filed any petition in this to seek to initiate or seek to force the communication with the plaintiff on those particular important decisions in the life of the child. And as a result, that's why the court states that he has in fact abdicated those particular responsibilities. In this particular case, it's clear that based under the appropriate statute that I referenced, that again, it's a matter of whether the parties are able to cooperate and generally agree, not always agree, as to important decisions affecting the welfare of the child, which they have not done. As a result of the fact that they have not done that, and that the defendant has not taken action to enforce that provision in any way, the court will recognize that plaintiff has been solely responsible for a good deal of the child's, well over half of the child's life, on making those decisions without any input from the defendant. As a result, the court does believe that she has met her burden of proof in this matter to establish that it is in the best interest of the child, based upon, again, facts that I will get into when I get into the best interest factors, that in fact it is in the best interest of the child. And the court will find that this by a clear and convincing evidence, even though, well, by clear and convincing evidence, the court will find that in fact it is in the best interest of the child that she be awarded sole legal custody, and the court will so order in this matter. I want to address next the issue of, again, the change in domicile. Change in domicile is covered by MCL 722.31 in this matter. And what the court has to look at, as Ms. Reed has already addressed, is the court has to engage in a 4-step approach. And first, with primary focus on the child, has the moving party established by a preponderance of evidence the following factors. First factor, does the change have the capacity to improve the quality of life of both the child and the relocating parent? The plaintiff has testified that, in fact, it does have the chance to improve the quality of life by moving to Tucson. And she points out that the factors that she looks at, she says, first, again, that she is going to go back to school. She seeks to have her cosmetology license, that she, in fact, would make approximately $70,000 a year in contrast to the $40,000 that she's making at the current time, that she has done some research in that. She's looked into the school. She has apparently acquired financial aid, which would pay for her tuition, that she would complete that training in approximately 10 to 12 months, and that they have an excellent job placement where there is potential for 90% of the graduates to get jobs, and that she would in fact have that opportunity in Tucson. Also has been much testimony about the house that she would have. The state been testified to by both her and Mr. Richardson that in fact the house that they would be living in is a house which would have 4 bedrooms, 3 baths, two living rooms, various other rooms in this particular matter, as well as a fenced-in yard, that in fact that it's more than able to provide for and to facilitate both the plaintiff and the minor child, as well as the plaintiff's other children in this particular case. So that would appear to be established in this particular case. The court notes that again, she's went through other things when she had testified. She testified that it appears that the student to teacher ratio would be greater in the school that the child would go to in Tucson. That in fact the child could, even though school started in Arizona last Monday, that she would be able to get her into school, that she would in fact be able to be enrolled, and that she believed that that school is superior to Fremont, which has a higher parent to teacher ratio and limited, I guess you'd say limited opportunities. She mentioned the one thing that her children, I think she looks generally, are involved in robotics, that in fact currently the child has exposure to that through the library, but if in Arizona, she would have exposure to that through a program through the local university, and that is preferable. Court notes as well that she testified in this case that that there would be other opportunities for the child being in the home where there is a 2-income household. She has testified, as did Mr. Richardson's, about providing for the child and supporting her during the time that the parties had, again, been together, and that Lauren, as he said, he looks at Lauren as his daughter, notwithstanding the fact she isn't. He looks at her, that he has provided for her in that way. The plaintiff has testified that other than the nominal child support of $25 per month, that the defendant has not provided for Lauren in this particular matter, other than that particular amount. And the defendant does not refute that. And as a result, the court is taking that into consideration. It does appear that based upon, again, all of the testimony, and again, the court can't reiterate everything, but based upon the testimony, it does appear that the change in domicile does have the capacity to improve quality of life of both the child and the relocating parent, and the court will so find. Next factor is the degree to which each parent has utilized their parenting time, and whether the change is inspired by a desire to defeat or frustrate parenting time. Clearly in this matter, although that is contested and disputed by the defendant, stating he didn't have a way to contact the plaintiff, that he states that her phone number was changed, that he had been blocked, and both his mother as well. The plaintiff testified that she's been on the same plan, which was paid for by her fiance for approximately 4 years, that her number has not changed, that in fact she has likewise not moved, that she's not blocked either the defendant or his mother, that and in fact, the court notes in looking at the file, he knows that he can pursue enforcement action as he has recently initiated as it related to parenting time, that likewise he could have initiated over the approximately 3.5 years a enforcement action as it relates to parenting time, and he has not done that until recently, until being informed that the plaintiff intended to move. So court will find in this matter he has not had the parenting time in the last 3+ years, approximately 3.5 years, and court will find that her move in this matter is not been, I guess you'd say, precipitated, if you would, or inspired by her desire to defeat or frustrate parenting time, which has not occurred for, again, the 3.5 years. Court addresses the 3.5 years only because the child's only 6, and court has found in the past, oftentimes, almost every time when you address issues concerning children, children have a different perspective on time. As you get older, your time changes. And children, I've had cases in which the children have testified, but children have also stated things such that something may happen, and a child may happen 3 months ago, 6 months ago, and children will talk about that event as if it was years and years ago. In contrast, for adults, it would seem like it was just maybe yesterday or just a little bit of time ago, but children, it seems like a long time ago. And in this case, again, the parenting time has not occurred in 3 to 3.5 years. So again, this child has very little, if any, maybe remembrance. And as the plaintiff had testified, she doesn't know the defendant. She has no relationship with the defendant, wouldn't even be able to recognize the defendant. But the court does not believe that she is, again, changing the domicile in a manner to frustrate or defeat parenting time. Next factor is whether the court satisfied change parenting time would preserve or foster the parental relationship of each party, and whether each parent is likely to comply. The court does believe that the parties would be likely to comply, although the court does have some question as to whether the defendant will, again, take advantage of and utilize the parenting time which might occur in this particular case. So the next factor is whether the party opposing is motivated to secure a financial advantage. There's been no testimony about that, so the court will not consider that in this particular matter. Next is whether there's domestic violence. Obviously, there's been testimony by the plaintiff, again, identifying and describing the domestic violence that she had with the defendant that he perpetrated, that in fact it resulted in criminal charges. It also resulted in her acquiring a personal protective order in this matter. So the court is taking all of that into consideration. Court believes that after the court identifies and reviews all of the factors, the court has to determine whether a change in domicile is appropriate, that the factors do support a change in domicile in this case. The court then has to look at, does the change in domicile, and does it in fact change the established custodial environment? An established custodial environment exists if over an appreciable time the parent and the children naturally look to the custodian in that environment for love, affection, guidance, emotional ties, and so the court, in looking at that particular those issues, the court notes that the statute provides that the age of the child, the physical environment, the inclination of the custodian of the child as to the permanency of the relationship shall also be considered. In this particular case, the testimony is shown and has been testified to that Lauren does in fact look to her mother for, again, the guidance, discipline, necessity of life, which she has provided for over that period of time when the defendant has not been involved, and for parental comfort. She's testified specifically about that again, there's signs of affection between she and Lauren, that they hug, that they have good relationship, that again, the court clearly believes that based upon the evidence in this particular matter, that in fact the established custodial environment is with the plaintiff mother. Then the court has to look, does the change in domicile, does that alter the established custodial environment? Court does not find that the change of domicile would in any way alter the established custodial environment in this particular case. So the court will not take that into consideration in this matter. As a result, then the court will find in this particular matter that a change in domicile is appropriate. The court will allow the plaintiff to change the domicile of the child to the state of Arizona in this particular matter. There's also been question then next as it relates to parenting time. There's been very little, if any, testimony as to parenting time other than that there should be a phased in process because there just hasn't been any contact for, again, that 3+ years in this matter. You can, again, you can look at what the basis was for that. The plaintiff will state that, well, there's been no contact because he hasn't initiated it. The defendant testified repeatedly, well, I attempted to, but I was not able to get a hold of the plaintiff. I was not able to, in fact, acquire the parenting time that had previously been ordered. The court will note, has been testified to, that again, there was proceedings that he initiated through the front of the court to enforce the parenting time, but he didn't appear at the hearing. And as a result, the matter was dismissed in this particular case. So the court has to look at, in fact, the appropriate statute, which is MCL 722.27A, and look at parenting time. Well, parenting time shall be granted when it is in the best interest of the minor child, and the court has to look at the best interest factors. The court, that's why I stated the court would look at those best interest factors as we proceed in this particular matter. First, the court has to look at the first factor is the love, affection, other emotional ties existing between the parties involved and the child. In this case, I've already alluded to the fact that under the established custodial environment, that the child and the plaintiff have an excellent relationship. There are signs of affection. They have emotional ties, etc. The record is almost completely void of any, I guess you'd say, a testimony on behalf of the defendant as it relates to this factor. And it could be because of the length of time that he's not had communication or contact. So the court will find that this factor does favor the plaintiff mother. Next factor is the capacity and disposition of the parties involved to give the child love, affection, guidance, continuation, the education, and raising in a particular religion or creed. Been no testimony about a particular religious upbringing, so the court will not consider that. But the plaintiff will note that she had talked about being involved in the school and that the child in Fremont School and in the current school, and that she has demonstrated the capacity and disposition to give the child love, affection, and guidance, whereas the defendant has simply asserted that, but there has not been an established relationship such as to demonstrate that in this particular case, the court will find that this factor favors plaintiff mother. Next factor is the capacity and disposition of the parties involved to provide the child food, clothing, medical care, and other remedial care recognized in place of medical care and other material needs. Clearly, the plaintiff has done this because she's almost solely been responsible for this for the time that the parties have not had contact. Again, they alluded to and addressed the fact that the defendant, notwithstanding the minimal amount of child support of $25 per month, that there has been enforcement action against him for payment of support. The court will take notice, if you would, judicial notice of the court's own file, and there have been various enforcement proceedings pursued against the defendant in this matter. And again, the plaintiff has solely provided all of the medical care for the child, and as a result, the court will find that this factor does favor the plaintiff mother. Next is the length of time the child has lived in a stable, satisfactory environment, and desirability of maintaining continuity. It does appear that Lauren has been in a stable, satisfactory environment for the last at least 3.5 to 4 years, where the defendant has not been involved. And the court notes that during that time, Lauren has not been in his care. So obviously the environment in his home is not a stable, satisfactory environment for the child. The court will find that this factor favors the plaintiff mother. Next factor is the permanency of the family unit, the existing or proposed or custodial home. In this matter, there's been no testimony from the defendant as to any changes in his family unit. There's not been any testimony about the change in the plaintiff's home, as there's perspective or possible change that she is engaged, but and she has a fiance, Mr. Richardson, as we've seen, but there's nothing else in that regard. The court will find that this factor doesn't weigh in favor of either of the parties. Next factor is the moral fitness of the parties involved. In doing so, again, there's been minimal amount of testimony as to this factor, but the court will note that the court can consider offensive behaviors as it relates to moral fitness, and some of that would necessarily be domestic violence. I'm not going to address that under this factor because it'll be addressed under factor K. Court doesn't find that this factor favors either of the parties. I will not weigh it. Next factor is the physical and mental health. There's been very little testimony, although the plaintiff has stated that she is physically well. She has no mental health issues, not seeking any treatments, not in any therapy or anything of that nature, not on any medication. And there's been no testimony from the defendant about this, but there's been no testimony that he is not in appropriate mental or physical health. The court will not weigh this factor in either party's favor. Next factor is the homeschool and community record of the child. Clearly, in this matter, the home record is in the home of the plaintiff, as she's not been in the home of the defendant for, again, 3+ years. She has been in school at Fremont. She's going into first grade this next school year. And again, it's been she and Mr. Richardson has been provided for the attendance at school. She stated that Lauren has not missed any school, that she's had good attendance, and that they provide the transportation daily for her to attend school. She's pretty young, so there's been no testimony about any community record. The court will find that this factor does favor the plaintiff mother. Next factor is the reasonable preference of the child. The court did talk to Lauren, and notwithstanding her being very hesitant to speak to me, I don't know if my reputation precedes me or if it had been simply blown up that I was some evil monger or monster or whatever, but she was very reticent to speak to me. But when she got in the room, she was very open, very polite, very direct, and really it was pleasant to speak to her. She even I guess you'd say she even rebuked me. I talked to her about how things were going in school, and she was fine. I related to her that unfortunately, when I was in elementary school, I spent far too much time in the principal's office, and she rebuked me saying that I shouldn't do that. And so she was very open. She did express a preference that the court is taking into consideration. Next factor is the willingness, and that factor, so the court is considering. The next is the willingness and ability of each of the parents to facilitate and encourage a close and continued parent-child relationship with the other parent. The testimony of the defendant is that the plaintiff has not been willing to do that she has not done that, but her testimony is that the defendant has not reached out. He's not sought to, again, take his scheduled parenting time from the order of 2019 until just recently, when in fact she was had filed the petition to change domicile and move. The court finds that in this matter that, again, the plaintiff has been willing to facilitate that relationship, but that in fact there has not been the attempt, if you would, to facilitate that on the part of the defendant. So the court will not find this factor to weigh in favor of either party. Next factor is the domestic violence. And there's been testimony about that there was domestic violence by the defendant. The court is going to take that into consideration, weigh that factor in favor of the plaintiff. Next factor is any other factor considered by the court to be relevant in the particular child dispute. In this matter, the court notes that other factors that are relevant in this case, the testimony of the plaintiff is that she has two other children whom Lauren has resided with her entire life. The court is taking that into consideration in this particular matter, and will take that into consideration for purposes of determining her best interest. So taking all of that in her best interest, and the court will then consider the factors the court has to look at in determining whether and to what extent the parenting time should be. First factor is special circumstances or needs of the child. The court determined there are no special circumstances or needs. Second factor is whether a child less than 1 year old. That's not applicable in this case. Court will not consider it. The next factor, likelihood of abuse or neglect of a child during parenting time. There's been no testimony about that, so the court will not consider it. Next factor is likelihood of abuse of a parent during the exercise of parenting time based upon the domestic violence. The court is concerned about that, but obviously there's ways to facilitate that, so I don't think that's an issue. Next factor is the inconvenience or burdensome impact of travel. Obviously now with the change in domicile, there would be inconvenience and burdensome impact of travel. However, that's something that could be worked out in this particular case as time goes on. Next is whether parents reasonably expected to exercise court-ordered parenting time. The defendant has not exercised the court-ordered parent time in the past, so the court takes that into consideration. Next factor is whether a parent frequently failed to exercise parenting time. The court would recognize, as I've stated, that he has not exercised his parenting time, so I'm considering that. Next is the threatened or actual detention of the child. There's been no testimony about that. And next is, again, any other relevant factors as I have testified or as I've stated in this matter, as the testimony is shown, is that the defendant has abdicated that parenting time now for well in excess of 3 years in this matter. So the court is considering that, and the court believes that based upon the testimony that there has to be a gradual reintegration of parenting time if the defendant wishes to do that. First, the court would in fact note that the parties aren't able to communicate, haven't communicated, and so the court will order that the parties would communicate through our Family Wizard app, and that in fact they would attempt to they would within 7 days of today's date, that the parties would basically acquire that app so that they can communicate. The court would caution each party so that they know, and I think that there's been testimony that the plaintiff knows at least that in fact that communication through our Family Wizard is kept through the app, and the court would have access to that. So that's good, because then the parties can't make false claim. Well, I tried to contact them, I didn't try to contact them, or whatever they might state. There's a record of that, so the court would be able to see that in a subsequent proceeding should that be necessary. So the court would order that the parties would enroll and acquire that apps within 7 days of today's date. The court would allow, in this particular matter, that the defendant would have an opportunity to communicate with Lauren through our Family Wizard app, or arrange through Zoom or other type of application like that, that he would be entitled to communicate with her for again, for I guess I'd say 1 day per week for up to half an hour, and communicate. I understand this is going to be difficult at first until the relationship can be established and reestablished. And I would state for your purposes, Mr. Wines, that the first couple or first few or whatever may be very short. That in fact, you may be only able to talk to her for a limited period of time, maybe a couple minutes or something of that nature. And in fact, what I'll do is, at least I'm going to change that for the communication would be for up to 10 minutes for the first, I guess I'd say the first 10 communications between the parties, between the defendant and Lauren. And then after that, it can graduate for another 10 minutes, so up to 20 minutes, then up to a half an hour for each succeeding 10 visits. So if the defendant doesn't communicate with her, so there's only been 9, it would be the next 10 before it would graduate and go up. The court would then, at that point, entertain the opportunity of the defendant to have some face-to-face contact with Lauren in Arizona or in Michigan, based upon where the parties may be. If the plaintiff is in Michigan, then it may be able to be arranged here, and that initial contact would be supervised with another third party that Lauren is acquainted with and familiar with, and that would be again a limited contact for, let's say, an hour, and that it would be in a public place supervised by I guess to say an individual of the plaintiff's choosing, but I would say not Mr. Richardson, as that may, again, be more awkward and a problem in this particular case, but it'd be somebody that Lorna would be very familiar with. After that, the court would entertain, again, as long as that's proceeded and proceeded well, the court would entertain a motion to expand for parenting time at that particular point. And I guess we can leave it at that and simply wait until all of that occur, and then we would have some parenting time in this matter. The court does note that again, there is apparently a referee proceeding in this matter that Ms. Reed had referenced to later this month. In view of the testimony I've heard and everything else, what the court is going to do in this particular case, especially with the change in the parenting time, the court is going to dismiss that referee proceeding in this particular matter, and that we would proceed with parenting time as the court has outlined. With that, I'll ask Ms. Reed, is there anything else that you believe the court needs to address or has failed to address before we conclude?
For child support, I'm going to need some tax returns or documents from Mr. Wines to calculate the order.
Okay, court will order in this matter, Mr. Wines, that you would provide to Ms. Reed your most recent tax return, if that's 2023, you provide that, and a recent paycheck stub showing year-to-date income, and that you would provide that to her within 10 days of today's date. Can you do that, sir?
So who, Jennifer Reed?
Yes, provide that to Miss Reed, the attorney.
Yeah, I could do that.
Okay, thank you. And
Sorry.
I guess I'll ask Miss Cannon, you can provide that to your Miss Reed as well, your most recent tax return and your most recent paycheck stub, and that at the time that you exchanged the order or provide that to Mr. Wines, Miss Reed, that you would provide him with that paycheck stub and a recent tax return as well.
Okay.
And the court would in this matter note, as the Ms. Cannon had testified to, that she paid for insurance of $70 per month for the 4 individuals. You would simply prorate that Ms. Reed as it relates to Lauren in this matter.
That's correct.
Okay. Anything else, Ms. Reed?
Just to go over everything one more time so I make sure that what I'm preparing is correct. So plaintiff is awarded sole legal custody. Her request to change domicile to Arizona is granted. For parenting time, the defendant is going to have either Our Family Wizard or Zoom calls with the minor child 1 time per week for up to 10 minutes for the first 10 weeks, and then 20 minutes for the following 10 weeks, and then ending in a half an hour. He has to be consistent in those phone calls and video calls, or that time resets. So if he's not consistent in like week 9 and he misses it, he still has to do 10 more weeks of phone calls. And then
not 10, that he'd have to do 10 weeks total, not that he would then have to do 10 consistent weeks, because I don't want to get in a position where he misses a week and then, okay, he's got to be 10. Once he has 10 in, then it would progress to the greater time.
He's got to have 10 calls. Okay, we just clarify that in the order. And then once he's graduated to a half an hour of video calls, which should be after 20 weeks of contact.
Correct.
Then we can schedule through the parties a visit. Is it 1 visit or is it multiple visits for an hour if she's in Michigan or he's in Arizona?
It's 1 visit initially to break that ice, and then the court will entertain a motion at that point to expand.
Okay. So after the 20 weeks of 1 per week phone call during a break or some other time when the child's not in school.
Correct.
They're going to arrange 1 in-person supervised visit for 1 hour in a public pace, not supervised by Mr. Richardson, but by someone who the child is familiar with. And then the court will entertain a motion to expand parenting time. And then child support is under the formula with the appropriate credit given for plaintiff's payment of the health insurance premium for Lauren.
Correct.
And then we are dismissing the referee here.
Yes.
Okay, I believe I have everything.
Okay, Mr. Wines, is there anything that you believe the court has not addressed or have failed to address before we conclude? You're muted, sir.
I don't have no way to Arizona. I'm gonna be going back to school and stuff, so, and I work a job in Battle Creek as well, so.
Okay, well, what happens is you're gonna have to, at that point, rely upon the plaintiff, if she happens to be in Michigan at that particular time. After that, Ms. Cannon, if you are going to be in Michigan after, again, those 20 phone visits, and the court would simply order that you would have to attempt to facilitate that face-to-face contact that the court has addressed.
Yes, Your Honor, I will.
Okay, it may be that you're not, if you're not in Michigan for months after that, obviously you don't have to make a special trip to do that. It'd only be, again, because the defendant's not obviously making the trip out to Arizona, so, but if you are here, we'll attempt to facilitate that. Oh, okay. Okay.
One more.
Anything else, Mr. Wines?
Yeah, when will the visitations for the wizard start?
Okay. I guess I will ask at this point, I don't know the party's work schedule, so I'll go to plaintiff first. Ma'am, when would you be able to work out and where those, I guess you say those video visits would occur? When would, is there a particular day of the week which is better and a particular time?
Your Honor, I believe Sunday will be good. That way she'll be free to talk and she can have her own quality time with him on the phone, and I'll make time for that.
Okay. Sir, would Sunday work?
Yes, if that works for them.
Okay. What time, Ms. Cannon, would work for you?
Sunday around 4 p.m. Be
Okay.
fine.
That work for you, sir? 4 p.m. on Sundays?
Yes, that'll work.
Okay. Okay. Then you can put, Ms. Reed, you can put that in, that those would occur on Sundays at 4:00 p.m.
Okay.
And how do I get this app that you're talking about? I'm not familiar with it.
What?
The Family Wizard, or I'm not
It's
familiar.
called Our Family Wizard. You can go to the App Store and you can look it up, and then you download it. There is a cost to utilizing that app. You'll have to set all of that up, and then what happens? You can then communicate with Ms. Reed's office as it relates to doing that. What I'll do is I'll order, and you can put this in the order as well, Ms. Reed, because in case they have some difficulties setting this up, et cetera, I'll have that the first visit would be on August 18, 2024. That way, we've got time to set it up and everybody has time to get acquainted with the app.
August 18th
Yes, August 18th would be the first phone visit.
at 4:00, correct?
4:00 p.m.
Okay.
Anything else, Mr. Wines?
Could you repeat that?
No, that's it.
Okay. Anything else as a result of what's happened, Ms. Reed, that we need to address?
No, Your Honor.
Okay. Ms. Reed, I'll direct that you would prepare that order and submit it for obviously for approval, and then provide it to the court.
All right, thank you.
Okay, thank you both. You're free to go, and I wish you the best of luck, and I hope things get back on again, a routine and for Lauren's best interest.
Yeah, thank you.
Thank you. You're free to go.
Thank
Have
you,
a good
Mr.
day.
You too. Bye.